With me is the very, very hardworking, gentle, polite, and patient, and a very firm believer in Nyay Sabke Liye, Justice for All, Justice UU Lalit, who is all set to be sworn in as the 49th Chief Justice of India. Justice Lalit, congratulations.
Thank you.
Please tell our viewers what your priorities are.
Priorities as what? As Chief Justice? Naturally, whatever the Chief Justice is expected to do. So therefore, see to it that the matters which are clogging the entire the board get disposed of at an early date. Naturally, the plan has to be to have those matters which become some kind of an example for. Once you lay down law, then the law as laid down in one particular matter can be followed in successive matters or group of matters which come up either before this court or which are pending in High Court or District Judiciary. So therefore, first and foremost priority is to lay down law. That's the primary function of Supreme Court, to see to it that all these matters are taken up without any delay. That should be the first and basic priority.
Your Lordship is taking over at a time when the pendency, the judicial backlog has climbed to around approximate 5 crore cases. And at the same time, and most of it has to do with the COVID pandemic. At the same time, Lordship's tenure is also around 2.5 months, 3 months long. But the procedure and measures laid on by the Lordship can help a lot. So how do you plan to deal with it?
See, the pendency, overall pendency all over the country is definitely up to the level of almost say 5 crores. So one part of cutting down these numbers is essentially through the employment of measures like say mediation, Lok Adalat or settlement. Yesterday in Lok Adalats we could settle more than 1 crore cases. Of course, out of these 1 crore, about 30 odd lakh were cases which were directly pending in court, and 70 odd lakh cases were those which were at the pre-litigation stage that we were able to nip them in the bud. Why do I say that? Because otherwise those cases would have come to the regular stream of courts and would have blocked the entire docket. So therefore, a sizable chunk gets disposed of in this fashion. But that apart, so far as Supreme Court is concerned, the pendency level is about say 71,200. This comprises of many matters, SLP level, at appeal level, civil, criminal. So therefore, let us not get into those distinctions or inter-compartments. But the basic idea is that if we settle the law, the primary function, as I always maintain, of the Supreme Court is to settle law. Once we settle law on any particular matter, then that law or the principles as settled will certainly govern the succeeding cases or the pending matters in other fora. So therefore, that's one way to take care of the pendency issue. Second part is that in this pandemic situation, what has unfortunately happened is that we have been concentrating only on miscellaneous or what is called urgent work. That is to say, if any stay is required, if any bail is required, so therefore those matters are getting listed. But what are the appeals? The appeals are unfortunately not getting listed, or the appeals are not getting disposed of because of lack of time. So therefore my priority would be to see to it, to chalk out a plan where all the pending appeals at least are given priority so that that backlog gets cleared completely. So that should be the priority.
Ever since the Lordship has taken over as the Executive Chairman of NALSA, the Lok Adalats, National Lok Adalats have witnessed record participation. So even as you said yesterday, in fact, day before yesterday, in fact, 1 crore cases were settled in Lok Adalat. Before that, around 95 lakh. So how far can these national Lok Adalats be deployed to bring down pendency?
You have answered the question. See, now, since I took over sometime in say May 2021, we have in these Lok Adalats, we have clocked a figure of almost 4 crore cases now. Out of those 4 crore cases, about 1 crore and 50 lakh are cases which were pending in regular courts, which have been disposed of. 2.5 crores were cases which were at pre-litigation stage. So therefore, one can understand that pre-litigation cases are otherwise not forming part of the number of pendency. But at the same time, 1.5 crore, if those cases which are pending in court, if they are getting disposed of, to that extent, the burden on the regular court, the docket, is certainly getting lesser. So therefore, whatever figures that you are presently seeing, that is say roughly about say 5 crore of pendency, just take into account that perhaps I think 1.5 crore has been wiped out as a result of Lok Adalats. I'll give you an example how it works. Say 138 of what we normally call check bouncing cases. Those are compoundable offenses. These are normally the business transactions where the checks are given. Checks, if they get bounced, naturally by mandate of law, that can result in an offense. So many prosecutions get launched on that count. But since the offenses are compoundable, people are interested in compounding, interested in settling the disputes. So therefore, through the machinery of Lok Adalat, we try to bring the complainant and the accused together. If they agree and if they settle the matter, naturally one case, which is a criminal case, goes out of the roster of every court wherever the matter is pending. So therefore, this is only one variety. There are MACT cases, there are accident cases, there are insurance cases. So therefore, these are cases which are blocking the docket of the court. So therefore, once Lok Adalat becomes successful movement, and every successive Lok Adalat will see to it that some burden or the other from the regular stream, on the regular stream, is taken care of. That's how Lok Adalats will definitely be useful.
And there's a feeling that the Supreme Court judgments are not changing situation at the ground level. Like people are still being arrested under 66A for social media posts. The Muslim women are still facing the vagaries of triple talaq. Hate speech continues. Prisons continues to be congested, and even now jail and bail is not the actual norm. How do you feel about that?
So you have combined 2 or 3 questions in one. Let me answer one by one. Jail and not bail. This is now the criticism. See, what is happening is many offences today come with a legislative mandate that bail should not be granted to the offenders. Say, for instance, NDPS law or Scheduled Caste, Scheduled Tribes Atrocities Act, or say POXO Act or UAPA Act. So therefore, these are various legislations which come out with these, what is called the burden which has to be discharged before the bail can even be granted. That puts some embargo on the courts granting bail so easily. It is true that cases like say Sanjay Chandra have decided and laid down that in cases which are not heinous crimes, where the sentence is a term sentence and less than 7 years, then bail should ordinarily be granted after completion of say 6 months of custody. But because of these compulsions, because of these statutory mandates, the trial courts normally do not grant bail. So therefore, as a result of that, today the scenario is that about 90% of our prison population, I'm saying 90% on an average. There are certain cases where the prison population may be lesser than that, but there are places where even 90%, in excess of 90% people are in jail. About on an average 90% prison population is under trials. And I keep emphasizing that if your conviction rate is just about 27-28%, or maybe say 30%, which means that out of these 90 persons who are the under trials in languishing in prison, finally 63 out of them are going to get acquitted. So out of, say, entire prison population, 60% people finally get acquitted. And that's where we have landed ourselves in. So therefore, this requires course correction on various issues. Number one, whether the bail kind of emphasis, whether the legislature should actually sort of, do some kind of modification in the burden which has been put, but that is of course for the policy makers. So far as courts are concerned, if the bail cannot be granted, then the other alternative is that very well the trial be expedited. But the trial getting expedited, you require a lot of infrastructure, a lot of manpower, a lot of sort of, the judge population ratio also needs to be improved. So these are again various problems in which everything gets caught. So that is answering your third question. The first part is that it is true that though there are certain decisions which are rendered by the Supreme Court, the law getting settled down, and yet the fruits of litigation do not go down to the last level. That's an unfortunate thing. See, as a matter of law, as a matter of constitutional imperatives, the function of the Supreme Court is to lay down law. Every other authority in the country is bound to implement whatever has been laid down by the Supreme Court. So if there are any infirmities in completing the process or in not following the letter of law to the hilt, then perhaps I think it is the executive which is answerable on this count. Of course, it is true that we get to see many contempt petitions filed. We try to implement to the extent possible. But finally, it is not for the Supreme Court or for the judiciary. It is ultimately for the executive to see that the principles laid down by the Supreme Court get followed to the T. So therefore, that's how it has to be. Yes.
Earlier, citizens were afraid to criticize judgments, forget the judges. But now there's a worrying trend of judges being openly criticized on social media, attacked on social media, particularly by people against whom a particular judgment goes, if a judgment is not the way they had expected. So what do you say about this worrying trend?
See, I always maintain that to the extent a judgment is subject matter of criticism, somebody may, a research scholar, say that, for reasons A, B, C, perhaps I think the judgment requires reconsideration, or the judgment may have failed to notice a binding precedent or a provision of law. Any such criticism is always welcome, because that sort of helps you in correcting whatever mistakes one has committed, and it helps in course correction, it helps in introspection, it helps in laying down something which in future will be in the position of correcting everything. So to the extent that such criticism is within bounds, and with that idea that perhaps what we are doing or criticizing is the judgment, or the principle or the analysis which has been part of the judgment, any such criticism should always be welcome in a healthy democracy. But the criticism of a judge who has rendered that judgment is not a healthy idea. So therefore, that's what I can say and maintain. Yes.
Your view on criticism of the collegium system of this appointment of judges?
I don't criticize that. It's a very unique feature that perhaps, theoretically it means that we judges choose our successors, correct? So therefore, that's a unique system that we in this country have adopted and which has been recognized. So I don't criticize the system as such, the principle behind that. It may be that perhaps the application of those principles in a given fact situation may call for some kind of, introspection. But that apart, there are various agencies who in the process are given that kind of burden or the duty to correct everything. So therefore there are agencies which will correct that. For instance, if a proposal emanates from, say, High Court Collegium, when it comes before us, there are consultations with the judges who may have had some exposure or chance with that particular court. Say, for instance, if the proposal comes from, say, Madhya Pradesh for appointment of judges, there may be judges from Madhya Pradesh who are presently in Supreme Court. There may be Chief Justices who were there as Madhya Pradesh Chief Justices coming from other high courts, but who are presently in Supreme Court. So therefore the consultation process requires that we consult these judges. Then there is an input which is given by the Government of India. So therefore, based on all these inputs and the basic sort of, the material, the final decision is taken at the level of the Supreme Court Collegium. So therefore, there are various checks and balances which are employed by the system itself, and to my mind, there is no room for any criticism.
Your reaction on courts interfering in policy matters? There's a lot of criticism, and it's also being termed as a breach of principle of separation of powers.
See, that's a debate which is again at a very different level. Call it judicial activism, call it sort of interference in policy decisions, but this debate or tussle has been going on for a fairly long time. We can count many judgments. Say, for instance, Madhuri Patil. For the first time, according to the judgment of the Supreme Court, correct, some mechanism to check whether a person belongs to the community, that is scheduled caste or scheduled tribe, which he projects, should be seen, should be screened. A committee was constituted under the orders of the Supreme Court. So that particular idea which emanated from the judicature or judiciary has been adopted as a universal model in almost every state now. Correct? So therefore, it was a case of judicial activism which has been accepted. Take for instance, after Islamic education case, which is again a bench of 5 judges, where fee committees for professional institutions admissions was constituted, fee committee, regulatory committee under the orders of the Supreme Court. Again, that is something which has been accepted. It was case of judicial activism which elevated a provision in the directive principles of state policy to the level of a fundamental right, that is right to education. So it was the dicta of the Supreme Court first. The Parliament intervenes later and then makes it, transfers it from Part 4 to Part 3. So there are cases where it has been taken in correct spirit, it has been accepted. So it all depends upon, going by that Vishakha law, that if a territory is something which is not governed by any principle of law, then to a certain extent, we in our jurisprudence, we have accepted that as a notion that the Supreme Court can certainly come out with, quote unquote, what is called judicial activism and start sort of, giving directions. Day in and day out, we have those kind of petitions. It ultimately depends upon what exactly are the contours of that petition, what exactly is the prayer, and to what extent the interference of the court is called for or would be justified.
Rashid, your decision to hold court at 9:30 a.m. one day had drawn enough eyeballs. And you had said that if children can go to school at 7 a.m., why can't Supreme Court judges sit at 9 a.m.? So will that now become the norm?
See, I would certainly prefer that, but I alone can't make that decision. The entire court, the entire body has to do that. I see certain advantages, and those advantages are, so therefore I have been discussing it with my colleagues. If they get persuaded, then certainly as an idea we can start that. I tell you that in the Rajasthan High Court, especially during summer, the courts begin functioning at 7:30. So therefore, it is not something which is unknown. It has been practiced. It is in practice for last several years or decades, correct? So therefore, it's a question of just getting used to that. To my mind, there are advantages are far greater than maybe inconveniences. But then we as a body need to take a decision on that.
So one last question, one last request. Your message to the country on the 75th year of independence, which is being celebrated as Azadi Ka Amrit Mahotsav.
See, my message would be something which NALSA stands for. Nyay sabke liye, Vishwas sabke liye. That's the message which must come from the entire judicial wing of the state. Nyay sabke liye, because that's the rule of law. So therefore, we are here to see that justice reaches every level, every nook and corner, every grassroots. And once it reaches Vishwas sabke liye, that's the zone of comfort, the confidence for every citizen that yes, there is an institution which is judicature, judicial wing, which will always be available in case any emergency or a situation does call for that. So that's the motto. Yes.
And I wish you all the best once again.
Thank you so much. Thank you. Thank you.